Fantastic. So before we get started, I would like to welcome Jennifer Minnick from Heartfields Assisted Living. Heartfields is our sponsor this month, and we really appreciate that. So Jennifer, if you can, I'm going to try to remove my spotlight and we'll give you the screen. There you go.
So unmute. Hi, I'm Jennifer. There's echo.
Yes, there is.
Sorry about that. It may not work for me.
Jennifer, please push the mute button on your computer and only have your volume on your phone.
Thank you.
Do you still have your phone on? So you need to unmute your phone. You're muted, Christina.
Yep. How long have we been doing Zoom, folks? We still can't get it quite right. Jennifer, I think we could hear you through the computer. If you want to try disconnecting from the phone and trying the computer again.
Okay.
There we go.
Working?
Yes.
Okay, I just can't hear you. So thank you for introducing me. I am Jennifer Minnick, the sales director at Heartfields Assisted Living, and we are super excited to be the sponsors again this month, and hope everyone enjoys the presentation. Heartfields is a community in Frederick. We consist of assisted living and memory care. We are a smaller community of 52 suites. We can be seen if you want to look at us on our website at www.heartfields@frederick-assistedliving.com, or you can put a message in the chat room and I'd be happy to reach back out to you.
Jennifer, thank you so much. And thank you again to Heartfields for sponsoring our webinar for the last 3 months. So appreciate you and all that Heartfields does for our seniors. So thank you very much. And if anybody has any questions for Jennifer, we'll also put her contact information up at the end of the presentation. So thanks, Jennifer. All right, so back to business. We'll get started with our featured speakers. We're very lucky to have 2 elder law attorneys with us today. I would like to introduce Lena Clark, who is a Frederick estate planning and probate attorney. Lena Clark, excuse me, let me start again. Lena Clark is an estate planning, probate, and elder law attorney based in Frederick, Maryland. Attorney Clark focuses on wills, trusts, special needs law, estate planning, trust and estate administration, family trust matters, and on related areas of federal and state tax laws involving transfers of family wealth to succeeding generations and planning after death disposition of property. She advises clients on estate planning documents and works closely with fiduciaries on probate and trust administration matters. Attorney Clark has over 18 years of experience in trusts and estate law. Prior to starting her own solo practice here in 2015, she worked with 2 large and 2 small firms in the Washington, D.C., Bethesda, and Frederick, Maryland, serving clients from all over the metro region. So we are very happy to have Lena with us. I also welcome Ryan Wilson, who is an experienced attorney who practices in Silver Spring. His practice includes elder law, estate planning, estate and trust administration, and small business and nonprofit advising. Prior to opening his own firm, Mr. Wilson spent a number of years advocating for financial and investor protection for AARP. And prior to that, he advised members of the Maryland General Assembly on a variety of issues. Mr. Wilson is a member of the Maryland State Bar Association, where he is a member of the Section Council of the Elder Law and Disability Rights Section. He's also a member of the MSBA Estate Planning and Real Property sections. Mr. Wilson is also an active member of the Montgomery County Bar Association and a member of the State Bar of California. Mr. Wilson is a member of the National Academy of Elder Law Attorneys and serves as secretary of NALA's Maryland, DC chapter. Mr. Wilson is also a member of the Estate Planning Council of Montgomery County and serves on the Montgomery County Commission on Aging, where he is the co-chair of the Public Policy Committee. So I am going to take the spotlight off of me and bring Lena and Ryan to the screen, and then we will get started. So thank you both for being with us.
You're welcome.
All right, give me 1 second. So there's Lena and Ryan. Perfect. There you go. So folks, we have admit. All right. So we thought we would start the presentation today. Even reading their bios, I must confess that I don't fully understand a lot of the things that they do because I don't understand all of those terms and words. So we thought we would start today by breaking down some of those things. And I'm going to start with you, Lena. Can you give us a little bit of information about what estate planning is, living wills, powers of attorney? Tell us what all of that means.
Yes, absolutely. So by estate planning, this is a preparation of legal documents for somebody who is 18 and older, for somebody who has a mental capacity. Typical estate plan covers at least 3 documents. One of them is called power of attorney or financial general durable power of attorney. It's a legal document that allows somebody else to make financial decisions on your behalf if you're not able to do so yourself. So you want to be thinking if somebody is in a car accident or had a bad case of COVID or had a dementia later in life, you want to have a legal document that's going to appoint somebody you trust to manage the finances for you. And of course, if that person is not available, you always want to have a backup person just in case. And unfortunately, being married is not enough. You do want to have the documents in place. Another very important document, many people call it living will. What we call it, it's called advanced medical directive. Advanced medical directive appoints somebody you trust to tell the doctors what to do if you're not able to do it yourself. Living will is also usually part of the advanced medical directive. And if you want to give a little bit more instructions, a lot more specific instructions what to do in case is there's a Maryland document called MOLST, Maryland Life Sustaining Treatment Form. That's another option, something you could fill out and helps it. Yeah. And then, of course, everybody knows the last will and testament. So this is a legal document appointing the person to act on your behalf when you die, to wrap up your final affairs, pay the bills, debts, expenses, taxes, consolidate all the assets, sell the home, and do the distributions. And also last will and testament helps you to deal with the court because that's a legal document court is going to be following by looking at the distributions.
Excellent. Lena, thank you. We're going to delve more into the details of some of those documents in a few minutes. But Ryan, can you talk us through a little bit about some of the other issues such as guardianship and conservatorship? And a lot of people associate Medicaid with the need for an elder law attorney.
Sure. So let's start with guardianship and conservatorship. I think one of the things that a lot of people started hearing about it was with a certain celebrity singer whose parents had a conservatorship. And whether you have a guardianship or a conservatorship depends on what state you're in. In Maryland, we call it a guardianship. In other states, they may call it a conservatorship. It's a statutory, it's created by statute in the law. It allows someone, if you are unable to, for certain reasons, to make decisions for yourself, either concerning your finances or concerning your body, yourself, they can get a guardianship. Either it's sort of split into two. There's a guardianship of the person and a guardianship of the property. You may need one, you may need both, depending on what it is. And Lena earlier mentioned a power of attorney. The power of attorney is your best defense against needing a guardianship, either for yourself or for your older loved one.
Excellent. And then do you want to talk briefly, Ryan, about Medicaid?
Sure, we can touch on that, just kind of give a broad introduction. So a lot of times people are familiar with Medicaid as it treats healthcare, but we're not talking about that here. We're talking about Medicaid as it treats long-term care for older clients and your older loved ones, or maybe your spouse, or it may be your parent or an aunt or an uncle, but it's something that helps them receive and pay for long-term care, specifically once they've gotten to the point of needing skilled nursing care. It does not pay for assisted living, except under certain waivers, and we're just going to like pretend that those don't exist, because that's like way more complicated than we need for
That's
right
a
now.
whole nother webinar.
That's a whole nother webinar, that there might be some things that people qualify for under certain waivers, but but for many people at later in their lives, they may well need skilled nursing level of care, either because of mental issues, physical issues. Usually it's physical issues. And sometimes it may be combined issues, as they are really sick and really need that level of 24-hour care.
Okay, and we'll again talk about that. Let me ask the obvious question. So in the day and age of the internet, where you can get virtually any document that you need from Google, why is it important that somebody seek out an elder law attorney? Why should we consult and do these documents with a real live person?
Well, I stopped fixing my own car a long time ago. And I take my car to somebody who can access the computer programs to know what's wrong with my car. I want somebody who's an expert in these sorts of issues, because they are complex issues, and I don't want to be doing it myself if I don't know what I'm doing. If I needed a lawyer to do something that I don't do, I go pay that lawyer.
And these are documents that if you don't have them right, you could get yourself, it could cause many, many more complications down the road, right? Because some of these documents, you really just have a particular window of time to get them done, that the person you're working with is capable of doing them, correct?
Pretty much, yeah. I think sometimes some of the problems that we see as an elder law attorneys, and Lena may also see these too, is that the documents that they've executed in the power of attorney, for instance, may not cover things that they need to do. Transactions that they may need may not be covered in the power of attorney, and then we're left with turning back to guardianship. Guardianship can only be obtained from a court, and can only be obtained if there's no less restrictive means at all. Well, the less restrictive means is your power of attorney.
So Lena, let me ask you this. So I'm helping my parents, they have no documents, there's nothing, we're starting from scratch. Where do we start?
We receive calls like this all the time. Many children and friends are concerned about the other family members missing documents. Sometimes the documents exist, but they're just very old. The suggestion is to schedule a meeting with an estate planning attorney in the place of your domicile. So if you're in Frederick or somewhere else in Maryland, you want to be looking at for estate planning attorney. Bring your documents, your parents' documents, whatever they might have, and typically attorney will ask you to fill out the questionnaire ahead of the consultation, so that way they know exactly what they're dealing with, and they can make suggestions what might be necessary.
And what do you do in a situation where you have multiple siblings? There's a lot of people involved. Not everybody's on the same page. What documents are important for people to put into place when there's conflict in the family, and how does one go about doing that?
Regardless whether there's a conflict or not, each person, so in this case, parents, the first question we will ask such a potential client, do they have mental capacity? If they do, we can absolutely help to prepare the documents. And it will be whatever the parent want, not whatever the multiple siblings might want. The siblings are often not involved unless they're facilitating and helping parents to come to see us or somebody like us.
So let me ask this question. Does the senior have to be have all of their faculties, have still very cognitively intact? And what do you do when someone isn't quite intact?
They should have enough capacity. I should be able to have a conversation with them. They should not, and sometimes, oftentimes you don't get a dementia right away. Sometimes you kind of, it's a beginning stages of dementia. So maybe we usually suggest then, based on this issue, is mornings are better or afternoons are better, and then let's schedule the consultation for that time or for the signing meeting, because they need to understand the nature of the documents they're signing. And we do have some clients and former clients that are in the beginning stages of losing capacity, but they understand enough for us to proceed with them.
Yes, exactly. We've seen the same thing. And I think what Lena is alluding to is you need testamentary capacity, where simply stated, you know what stuff you have, you know who you want to leave it to, and you know what you're doing while you're doing it. Dementia isn't something that like a switch that flips. It's something on a continuum, and you may be in early stages, but still being able to function enough to be able to have the right kind of documents.
So I may not be able to balance my checkbook anymore or follow a detailed recipe, but I still know which kid I want to do what and how I want my own affairs handled. So I would still, even though I wasn't as sharp as I used to be, I would still be able to work with an elder law attorney to get all those documents put into place.
Absolutely.
Excellent, excellent. So let's say you've done those documents. Does that mean that your children can immediately, or I'm using children as an example. It could be someone else in your family or a trusted friend, correct? It doesn't have to be a family member that you appoint. But does that mean that as soon as those documents are drawn up, that they can start handling my affairs?
Financial affairs, absolutely. Medical affairs, the test is typically 2 doctors examine you, declare you mentally incompetent. Only then they will be listening to somebody else, whoever is on a advanced medical directive. Yeah.
I think it always depends on the document. You know, sometimes people want it to be what's called a springing document, which means it doesn't happen until there's a condition, which is the later thing that Lena mentioned, that kind of condition, or it can be something right away. But even if it's right away, there are parameters around it. It can't be like they can go, like your child can go out and use your checking account to buy themselves a new car, for instance. They have to be acting on your behalf. So if it were something where you couldn't get to, I don't know, if you were out of town and couldn't pay your mortgage, for instance, they could do that for you. Something like that.
But there are guardrails that you can have in the document so that someone couldn't, like you said, just go buy a car or, get into your financial business without you being really ready for them to take over.
That's correct.
Okay. So what about a family that doesn't really have anything. There's nothing to speak of, no property. Can we talk about wills and testaments? If someone rents a home and doesn't really have a lot of assets, do they still need a will?
They should have a will, absolutely. They might not have a car, they might not have a home, but they still gonna have at least something. They might have a checking account, maybe a savings account, maybe some retirement accounts, maybe annuity or life insurance. So they might receive some refund from somewhere, but after they die, you want to have the documents that's going to be appointing somebody you trust who can sort it out if needed.
So really, anybody over the age of, you said 18, those are things that you should start thinking about. So not just the senior, but the caregiver should probably also have some of these documents as well, correct?
Absolutely.
Excellent.
And Lena's experience may be similar to mine, but a lot of times people start thinking about it after they've cared for their parent or some loved one of theirs has passed. They think, oh, I don't want to put my loved one through the same thing I just went through.
Absolutely. And pre-pandemic, our average client used to be starting from age of 40 plus. During the pandemic, we've helped a lot of very young people who started thinking life happens, unexpected happens. I'd better have at least basic stuff in place. It doesn't have to be elaborate trust right away, but absolutely.
And so let's say that someone does that for planning ahead, they're younger, or my parents did this, back 20 years ago. Should those documents be reviewed at certain intervals? Are there times that those documents would change? And could a document ever expire?
As a general rule, they don't expire. But should they be updated? Yes. My rule of thumb is, if you've had a change in your life in some way, shape, fashion, or form, then it's time to update your documents. If the last time you drafted a will, for instance, was when your children were young and still minors, and now your children have their own children, it's time to update your will. If the last time you had a will drafted, you were married and now you're divorced, it's time to update your will. If you had the last time you drafted your will and you weren't married at all, and now you're married, it's time to update your will. All of those life changes make differences. And there may be other changes in your life, but it's always good to review every few years, just in case. I've had clients come in who had wills drafted by other attorneys 5 or 10 years before they came to me, and they said, do we need to change it? And I said, are your intentions the same? Yes. Then you can leave here after the consultation fully confident that your documents are still right.
Where do those documents go? Where do they live? Where should they live?
Lena?
Well, there are a couple of places. I guess general kind of misperceptions that the documents have to be filed at the courthouse. The only document you can file as a courthouse is your last will and testament. It's in Maryland, it's cost $5, and then you go to your county and file it. You want to be careful if you do that, because if you prepare a new will or make a changes, prepare a codicil to your will, or you move outside of your counties, and you want to make sure that you either collect the old will or move it to a new county, and it's always on you to make sure that you remember to collect it and destroy it, but that's an option. And of course, when you prepare a revocable living trust and place real estate like your primary residence in the trust, that document is definitely gets recorded with the land records. Other documents, we scan all the documents for all of our former clients, but then they decide to where they're going to keep it. It could be safe in a house. The question is then, who has an access? Is it just you and your spouse? What if something happens to both of you? Do your children will have an access? Do you have a code maybe, or a spare key hidden somewhere, and your key people will know where to look for that information. You don't have to give it to them right away, but maybe have a discussion where that secret information is going to be. If another very popular option is to maybe keep it at the bank in safety deposit box, again, the question, who is on the safety deposit box? If you're not able to do it, your family is not going to be able to get into it without a court order. So perhaps if you trust one of your family members, maybe your children, maybe add them to it, do whatever the paperwork needed, so that way your child can access it, should you not able to do it yourself.
I think one of you had mentioned previously a trust. What is a trust?
So there are multiple trusts. The most popular trust, I would want to say, is a revocable living trust. So revocable living trust is a legal entity. If created right and updated correctly, it will avoid the probate process. So typically when somebody dies with a will or without a will, typically there's a probate or estate administration at the local courthouse, and then assets are tied up and attorneys are paid, and they have to go through a lot of red tape, and families busy collecting information, getting information that's will be necessary otherwise. If done correctly, revocable living trust avoids that. So that's kind of the primary reason to create revocable living trust. Another very popular option to create a special need, to create a revocable living trust, if you have minor children, if you have minor beneficiaries, I want to say, or you have somebody special in your life who receives government benefits because of because they have special needs. You want to protect the inheritance they're going to receive in the future, and you also want to preserve it in a certain way, so that way they continue receiving both after your passing. So avoiding the probate, providing for vulnerable beneficiaries who might be minors or special needs. Also, if you have real estate outside of the state of your domicile, that would be another very important reason, because you want to avoid probating your property both in Maryland and in another state. And it's a little bit more nuanced, but those are kind of the top reasons. And of course, privacy. Anything goes through the courthouse as a public information. Nowadays, you can retrieve it online. You pay 50 cents per page and can see all kinds of information quickly. Trust.
Okay.
Do not get recorded, and they're private.
Interesting. I did not know any of that, so thank you. And it again speaks to the just consulting with a good, knowledgeable elder law attorney when you are considering any of these things. Someone has asked a question, the benefit of a let me pull that back up. Testamentary trust?
Sure. So as Lena was mentioning, trusts are very, well, they're very utilitarian. They're flexible, and it depends on what kind of trust you use. So somebody mentions a testamentary trust. That's a trust that's created inside the will. You can do that if you elect to have a will instead of a revocable living trust to be the main tool of your estate plan. But you may want to have a testamentary trust, for instance, if you have minor children, to take care of them when you're not around anymore, so that they can have a glide path to their inheritance instead of getting it all in one lump. You can have a testamentary trust. Lena mentioned what's called a special needs trust. Sometimes they're called supplemental needs trust. They're the same kind of trust, but there's someone there for someone who has government benefits that protects them in such a way that they can still retain their government benefits and have a trust that provides for things that are not covered by their government benefits, like it can cover many different kinds of things. For instance, if they needed a special van to travel in, for instance, or to go to their doctor visits, or all kinds of different things that it might cover that are not covered by the government benefits. So it's really a flexibility issue. And it's something that's created inside your will.
All right. So let's talk a little bit about my parents. My mom has gotten ill, can't take care of herself. Dad can't take care of her. We're looking at nursing home placement. They don't have a lot of money. We're talking about, the nursing home is talking about Medicaid. When someone enters the nursing home with Medicaid, does that mean that my dad at home would lose the house? Would he have to give up anything? How could he possibly live if they took all of his money? Can you guys speak to that a little bit?
Sure. So that's really where you need to come speak with an elder law attorney, because there are complicated rules under Medicaid that say what counts as an asset of the person going into the skilled nursing facility. Medicaid will pay the difference between whatever money they have and the cost, or the Medicaid cost of the care. So one of the things that typically is going to have to go to be assigned to the home is any pension or other income that that person has, that spouse has. But other assets might be able to be transferred, especially when we're talking about spouses. The rules are a little different for other individuals, for other transfers, but for spouses, certain transfers can be made without any kind of penalty. Other transfers might be made under certain circumstances. It's just, what's the right answer for any one person? Which strategy is going to be right is going to be different. I have a client right now who they had a very unexpected need for a nursing home because one of the spouses had a stroke at a young age, and they were definitely not anticipating that. And so the transfer of the home was able to go to the community spouse without a penalty. Other assets had to be transferred in such a way it's not really going to cause a penalty so much under Medicaid, but there may be some other costs associated.
The whole Medicaid process can be very complicated. That would be an understatement, right?
Yes.
Excellent. We talked about this a little bit, but I think it bears repeating. So a person who has a diagnosis of dementia can still sign many legal documents legitimately, as long as they can still understand what they're signing, correct?
Yes, it's not a straight line. It's not like, oh, dementia, can't do it. It's, do they understand what they're signing and what the document does? Do they have testamentary capacity if it's a will? Do they have capacity to understand that they're signing power of attorney? It may be a good time to get the power of attorney if you know that your loved one is starting to get dementia. You will want to go to see an elder law attorney soon to get the power of attorney in place so that you can avoid having to get a guardianship for your loved one.
And so let's speak to that for a second. So you haven't done those documents early on, and now mom and dad or sister is really well advanced into the disease and cannot, by anyone's good measure, really understand what they're doing. So what is the end result of that? You mentioned guardianship.
I mentioned guardianship, and remember, guardianship is something that you do in court. It is court supervised. You have to go through, for all intents and purposes, it's a trial. You have a hearing. You have to prove ahead of time. You have to provide doctor certificates. You may be able to get two professionals, we'll say that. One of them, at least one of whom, has to be a physician. The other one can be a physician or a social worker or something like that. But they have to certify that the person actually needs it and can't make those decisions on his or her own. And then you have to go through the process of a hearing. If the person, the alleged disabled person, we'll call them that, because they're not disabled until then. But that person is entitled to a lawyer as well, who can argue that they don't need any such guardianship. Sometimes that happens. That's called a contested guardianship case, and they can ask for a jury trial. If they're not in that situation, if they're not contesting, there's still an issue of court supervision. Ultimately, the court is the guardian, and the guardian is answerable to the court, including annual reports to the court on, I mentioned it's bifurcated, guardian of the person and guardian of the property. The guardian of the property has to show what things were that they spent money on of the person. Say, for instance, they have a checking account. They have to show the court those statements of the checking account and all the things that they spent money on.
So go ahead, Lena.
I was just going to add, typically you also need two attorneys, hire two attorneys. One is going to represent the family, one is going to has to represent the alleged disabled person. So you're talking about a lot of money under very stressful circumstances, and a typical guardianship uncontested, it takes about 3-4 months. And then
Wow.
of course you have to get an attorney to do annual accountings and inventories on an annual basis typically.
So it's definitely something you want to avoid if you can plan ahead early. And even if you haven't planned ahead early, not every person with dementia needs a guardian, correct? It's really only when it's complicated or there's no one else to speak on their behalf, or am I wrong there?
I think that there are different things that you can do. Guardianship is the kind of the last stop. It's if there's no less restrictive means possible. And we've talked about one of those less restrictive means is the power of attorney. If they've executed, if they've come to an attorney and gotten a good power of attorney that allows them to do what they need to do, then we can avoid that. For some people in the early stages, or if they're disabled and have maybe some other problem, there's a new law that is taking effect this year that allows for what's called supported decision-making. And that's something that allows someone that they've named, maybe it's an adult child or some other trusted advisor, to go with them and help them make certain decisions, but that may not be all decisions. So, but guardianship's kind of the end of the line. There's no less restrictive means available, and it has to be for certain causes.
All right. Folks, at this point, I would like to encourage you, if you have questions, to please put them into the chat box. We definitely want to take advantage of having Tim and Lena here with us. If you have questions, go ahead and put those in, and we will read those back to you. But as we wait for those questions to come in, can you guys speak to just a nuggets of advice or best practices? What are some of your suggestions for the folks who are listening here today to either be prepared for themselves or to be prepared for the person that they're taking care of?
I guess maybe common misperceptions or some things that we hear from clients often. They say, I have 3 children and I would like all 3 to act on my behalf. Doesn't matter what's the document jointly. They're all gonna talk, come up with the best decision. I usually always advise against that. Even if they're well-meaning people, they get along wonderfully. Number one, they could be living far away from each other and they're busy with their own life. Every time they're going to write a check, all 3 are going to write, sign their name on a check. Some banks will not even deal with such a family just because it's a lot of responsibility to a bank. What I usually recommend, pick one decision maker who can make the best decision maker for your under your circumstances. And if that person is not available, whatever reason that might be, they might not want to do it, they might have predeceased you, then next in line person can act on your behalf. So that's kind of comes up often.
Interesting. Ryan, any wise nuggets?
Well, that's a great one that Lena just came up with is choosing the right person. I think the other thing is, you know, the time to get started is now, before something happens, before it's too late.
Good, that's good advice, planning ahead. I think by nature, we all tend to wait and then it is too late. But we've got some great questions coming into the chat box. So can you share some, when someone is seeking an elder law attorney, what are some things that they should be paying attention to as they make that decision? And this person questions, is it location, cost, experience? What are some key things that a person should be focusing on when they're choosing an elder law attorney?
Sure. I think location may be one of the things. Part of it is, it's really more of an issue. Many things in Maryland are statewide. Medicaid, for instance, is statewide, but every jurisdiction's a little bit different in some ways or another. So you want to ask them if they're familiar with taking cases in Frederick, for instance, or if they are in Montgomery County. It might be a little different, even though the rules are the same. There might be some other local rules that they might want to know about.
And so I suppose just like choosing a physician or something, you want to be comfortable that the person has your best interest at heart, that you're comfortable with their communication, you know, getting through to their office and being able to make an appointment. Those are all very practical things.
Very practical. I think the other thing is, you know, how you feel about it and how they communicate with you. If you feel like you have a rapport with that attorney, then that's an important thing, because it's really a personal level. So you have to develop some trust and rapport.
Someone's asked, what is the average cost to prepare a will? Is there an average cost?
So what we typically say, unfortunately, so many people call us and say, I just need a simple will. And in my years of practicing, we have, well, I had my own law firm for the last almost 8 years. We have exactly one former client who walked away voluntarily with just a will. Most people, once you talk to them, explain pros and cons of each document. Most people want, everybody wants medical directive. Most people want financial power of attorney, a will, and maybe some other things. Unfortunately, this is not a commodity you can just kind of give a quick price without a lot more information. So unfortunately, we can't do that unless we have, we know the facts, we know the goals, we know the, you know, what the person wants. So that typically requires a consultation, questionnaire, and things like that.
And you had mentioned that before, Lena. Ryan, I assume also that there is a lot of data that you collect to have an understanding of what these documents might encompass for this particular family.
Absolutely. You know, there used to be a car on every car commercial. They used to say your mileage may differ, and your results may differ because your situation is going to be different from everyone else's. So, you know, asking us to say, well, what's the simple one? What's simple to you? What is it you need?
Here's a question that perhaps isn't so simple. In Maryland, is it legal to include your companion animal as a beneficiary in your will or trust? And how would this work? And are there lawyers that specialize in animal law?
Yes, and yes.
Okay.
So yes, you can. And in Maryland, we have by statute what's called a pet trust that allows you to care for your pet. However, you know, and your pet may be, you know, it may be a dog that has a very long lifetime and you're kind of older, or a cat that has a very long lifetime. You know, animals have different lifetime lifespans. If your pet is, say, a Great Dane, it may only live 8 years. But if your pet is, an average house cat, they may get 15 or 20 years. It depends. Or a horse. If you have a horse, for instance, they can live to be well over 20 years old. So it depends. And the pet trust can name, there are certain things that are a little bit different about that. Special rules concerning that are not the same with other trusts. For instance, since the beneficiary of the trust, the pet, can't go to court and enforce it, you have to have someone else who can, in addition to naming a trustee. So they're a little bit different. There are some rules along with that are special to pet trust. There are some attorneys who do those kinds of things, some who don't. You ask around whether the attorney that you're working with does.
Excellent. Thank you for that question and for that response. So someone's asked the question, what should I consider when deciding to continue paying the premium on my long-term care insurance? Is that something either of you feel comfortable responding to?
I can answer a little bit more broadly speaking, and this is not yours, but you want to know what it covers. You want to know what it pays for, and you want to know how much you're paying. Generally speaking, for a lot of people, especially if they bought their long-term care insurance some time ago, it's well worth it to keep doing so, because that long-term care insurance covers more than just nursing home care. And it also may have certain inflation protection that even new long-term care insurance policies don't have. So it really depends on your policy and what it covers and all those kinds of things. But you want to check it out, and you may want to review it with your insurance professional.
Excellent. Here's another question about capacity. So our questionnaire writes that mom's doctor's note regarding her capacity to make decisions was a gentle, quote, short-term memory loss, which doesn't really describe that mom, after a stroke, doesn't understand anything about money and money decisions. If the doctor refuses to write a stronger letter, what recourse do I have?
We get those type of calls from time to time. What we typically recommend is to get doctor certificates and tell the doctor, I'm scheduling this medical appointment strictly to evaluate and fill out the doctor certificate for the purposes of guardianship. It's a 7-8 page document, and where a doctor has to describe the condition. And in 2 places, they do need to recommend. They recommend guardian of person and guardian of property. So that's kind of will force a doctor in a way to actually let them know what they think if guardianship is necessary. And in my experience, oftentimes the clients who call about something like this, oftentimes they do, or they have a financial power of attorney and medical directive in place, but they're afraid to use it, and they do not want to go over the boundaries with the parent who used to raise them and used to change their diapers. And that kind of letter is going to help them and say, look, doctor says that guardianship is necessary, so I should be comfortable using the medical directive and financial power of attorney if one exists.
So Lena, you're suggesting that form may be useful to have the doctor fill out, even if you're not going for guardianship, but just to give you some peace of mind that, yep, the doctor really thinks she's advanced and can't make her own decisions. Absolutely. So I feel more comfortable with that. Interesting. Good feedback. I hope that answered your question. Does anybody else have any other questions? We have a few more minutes. You guys have given us some great information. Certainly my wheels are turning. I'm going to make sure that my mom's got all these documents, and probably need to be thinking about them for myself as well. Let me just look through the chat here. Here's a great question. So what if my parents won't talk about their plans or whether or not they've done a power of attorney? What if they're keeping quiet on everything. Do you guys have any advice?
Always a tough one, because I think that's one of the things as Americans um, we are most loath to talk about with our loved ones. We're more than willing to talk about all of our medical conditions and private things of that sort, but our money seems sacrosanct, and we're afraid to do so. I think it's really just sort of it may be a long-term issue of childhood nagging, child to parent nagging, and saying, look, I really want you to get this stuff in place, because I want things to be a smooth transition if you're not here anymore, when you're not here, because we're all not going to be here at some point. And I want to be able to have it in place so that we can take care of you if you can't, and we're worried about you. And it's a tough conversation, just like it's a tough conversation. I think Lena mentioned, you were their child. They're always going to think of you as their child. You're going to think of them as their parent, but at some time they may not be able to care for themselves anymore. And then it's time for somebody else to be able to step in on their behalf. You're not stepping in to take over and be their parent so much as you're stepping in to be their agent to help them.
And that's a good way perhaps to try and explain it to them. These conversations can be awkward and hard, but the challenges that result later if you don't have these conversations can be much harder and much more complicated.
And sometimes you might not succeed. I just recently lost my father. He was never sick, young and healthy, 68 years old, just passed away. And unfortunately, sometimes, and I used to have a conversations with my parents. Do you have a will? Do you have a basic documents in place? And they were very secretive. Well, not so much secretive. They say, well, we're not planning on dying. And I would say, well, I just recently had change of circumstances, so I updated my will and my trust. What about you guys? Have you done this? And they would say, well, we're not planning on dying. And they would laugh at me.
Oh, Lena.
That's just, it happens.
It does, and you can't,
Does.
none of us can predict when. So that's a great story, and maybe sharing that story with your loved one. None of us expects to die, but it will happen, right? Death and taxes. You can
That's
count
true.
on it.
Nobody gets off this planet alive, and we don't get to choose our time.
So Ryan and Lena, you guys have provided some great information. We've got a big crowd with us today, and I really appreciate both of you taking the time out of your very busy schedules to share the information that you have. We do have a slide that's going to give your website information if people are interested in learning more about your practices. We'll put that screen up so they can copy down that information. And again, we really appreciate all of your time. Rayanne, do you have that screen? There we go. Perfect. All right, so there's the contact information for Lena's office and for Ryan's office. Again, we appreciate both of you. I also want to say thank you to Heartfields Assisted Living for sponsoring our webinar today. Again, please give them a call if you have questions about their assisted living community. And I will share that our next webinar is scheduled for September 14th. We're changing around the schedule a little bit, so I don't have the topic yet. But as soon as we have that put into place, I will send an email out so that all of you get that. So with that, if there are no other questions, I'm going to say goodbye to everybody. Have a wonderful afternoon. Stay cool and take care. Lena and Ryan, thank you again for everything.
Thank you for having us.
Thank you for having us.
Thank you.